report, you see that they lay out the specific claims, you identify the specific facts, the references to the record, to provide the basis for that. There's an attachment as identified as Exhibit 1, which is a copy of that tracer report showing the failure to file the complaints or file the requisite reports during the period of time. The candidate affidavit identifying who the proper respondent is and their contact information, and that's the way it works. And then what's the initial kind of response? Well, first, the Secretary of State's office gets this complaint. They review it for the fact that it's got a cover letter and it's properly filled out, and then the Secretary of State's office refers it over with the cover letter, which is what's identified on page 2 of your handout, over to the Office of Administrative Courts, and then it is this copy that it is then provided to the respondent. Now, unlike typical rules of procedure that require the complaint to be served upon the person personally, typically these complaints are just simply mailed to the mailing address. Now, that has in the past presented some problems when a candidate committee has a P.O. box and they don't check because it's not in the middle of election cycle, and so there are some issues with respect to notice and service and that sort of stuff. But that's the process we've got in administrative courts, where service can be done by mail or fax or email in the context of some of these complaints. But that's something to be aware of, that you don't have to serve process as you might see in a typical civil complaint. It's done by the Secretary of State's office, sends the copy of the complaint by mail to the respondent. And then the respondent has a period of time, because the hearing date is set within a very short period of time, and it has to be set again within 15 days. The typical approach and response is that either the complainant, or excuse me, the respondent themselves, the candidate committee representative, the representative of the organization that's being complained against, will file a motion asking for a continuance of the trial, and typically the approach is to request that there be a setting conference to postpone the trial for at least 30 days or longer, or a status conference to lay out if there's preliminary issues of discovery or a briefing schedule. Typically at that status conference, which is almost always done by telephone with the administrative courts, the various parties can talk about what they think the case is going to lay out. If the responding party believes that they intend on filing a motion to dismiss, and this is the reasons why, that they'll lay it out to the board and ask for some timelines with respect to when those briefs should be submitted, response briefs, in somewhat of either a formal or an informal case management order is proposed, and they sort of go from there. Otherwise, typically the setting conference is, okay, well, when do you want to reschedule this hearing for? And they'll schedule it out 30 days or 45 days. Typically not much further than that. I mean, it's pretty unusual to get an extension on hearing rescheduled for more than a month or two, unless you're really kind of laying out the idea that we're going to be filing motions to dismiss and be able to take care of the issues of the factual record, either through stipulations or that there are no facts in dispute, and it just becomes a question of law that the ALJs could potentially rule on the briefing. So that's the kind of the way it works.
So one point I want to hit before we kind of move on to the next phase here, when we're talking about the parties and sort of getting this thing served or moving on, as was discussed in the last presentation, a large chunk of the cases are like this one you're looking at here, starting on page 3, where there's something in Tracer, they print it out, these are the registered agents, this is the committee, this is who I'm suing because of what they've done. But there's also a large chunk of cases, and to be honest, these are the ones I've been most familiar with lately, where it is some sort of outside entity who isn't in Tracer. It's a failure to file, a failure to even register and submit yourself to the system. And so as a practice point, you do have different considerations trying to figure out who the organization is. You don't have a registered agent with contact information, dialed up for you in Tracer right there. So it's a different process to be able to really figure out who is it that I need to sue and who are the proper representatives, and then maybe they need to then hire counsel, and then you have to get involved discussing with counsel. So I just want to kind of raise that as a slightly less streamlined version of these cases when you're dealing with the failure to file, because you do have an entity that's not already submitted to the system, as it were, in Tracer. And so it kind of brings some slightly different hiccups into that kind of process. I've done it a number of times and it's worked out, but it's a slightly different process there.
Yeah, in fact, let's take a look at an illustrative example of that. Beginning on page 35 of your handouts, here's the example of a case that was referred by the Colorado Secretary of State's office to the administrative courts involving an allegation that an entity was engaging in activity designed to influence the outcome of an election related to an issue, so a ballot measure question, against an organization that was not a registered committee. This is a complaint filed by John Andrews against an organization called Compassion and Choices Action Network. And the allegation was that they were spending significant amounts of money to support a particular proposition, and that they failed to register themselves as an issue committee. You can see here's a slightly different approach with respect to that complaint process. It's laid out more in the style of a litigation-oriented civil complaint. Interesting to note, this is typically the caption and heading and formatting structure that happens before the administrative courts, but many attorneys and many, in terms of responding, typically respond in a standard block format with the caption and the case headings and all that as well. I've never had any issues either way, but just to let you know that this whole format of having the heading for the South Carolina Secretary of State case heading is a little different from most practitioners what we're used to, and it's perfectly fine and appropriate to file these cases. In fact, this is a more common approach. But you can see this is a situation where the responding party is not already in the system, and so you've got to, if you're the complainant, identify with some specificity who the entity is, how to contact them, what their address is, typically if it's a corporate or a nonprofit entity, who the registered agent is for the purposes of those filings, who gets served with notice of those complaints. And it would be recommended very strongly, just as this one does on page 37, if you're going to identify those parties that are not already in the system, that you identify them with some degree of specificity as to why they're subject to this. For example, in this case, under the heading parties and jurisdictions, district jurisdiction, you identify, the complainant here identifies specifically who the entity is, what its legal status is, what its mailing address, where its office or registered agent is here in the state of Colorado. Question?
So for those entities that are already in our system, but as you say, may be dormant in some way, is there a suggestion that you can make as to ways in which we can maybe change our rules or expand how somebody could be noticed in a way that would allow them to participate in this potential action?
It's a good problem. Our good question. So to repeat it for the record, the question was, is sort of how can we make this process for those that are going to be responding to these complaints, if the only essentially notice they get of it is if it's sent to a PO box or a mailing address that might not be checked or might not be on their radar screen. You know, I would like to see some reforms made to the Administrative Procedures Act as it relates to requiring a more formal notice, so that people really do in fact get a personal service, or at least something that is more than just an email heads up, hey, this is coming, or a mailing sent to a post office box, particularly if the address is something that is like a post office box. It doesn't actually have a person there picking up the mail. But again, that would probably require amendments to either the statutes with respect to how these complaints are noticed, or the Administrative Procedures Act, or perhaps rules governing the OAC courts. I mean, that's another way that we could potentially address this, what I think is a bit of a failing. There's also some questions as to jurisdiction, as to whether complaints can be filed against out-of-state parties. It's entirely possible and likely sometimes that folks are spending money to influence elections here in Colorado, and they're out of state. There's a question as to whether the administrative courts have jurisdiction or can take jurisdiction over them, or a complaint can be served or filed against an out-of-state party. Those are questions that really haven't been, in my opinion, adequately addressed or resolved.
And Judd, I would just add that also, similar to the way that the Secretary of State rules and statutes require committees and folks who are registered through Tracer to keep their records for a certain period of time after election in case complaints and things happen, I think there's probably things that can be done at the Secretary of State's level to make sure that current contact information is updated with your office. Like if they haven't terminated the committee, then it gets terminated and there's a process for that. But for those committees that are lingering but not terminated, I think your office has the authority to make sure that you guys have current good contact information for those committees, because they're active, they're not terminated. And so I would suggest that would be one way too, because your office would have other uses to make sure that you can contact folks that are still in your system as well.
Just as a side note with respect to these lingering committees, it would also be nice to have some mechanism in law that after a period of time for committees that are lingering, even if they've got these quote-unquote negative balances as a result of campaign finance complaint against them, that there is some mechanism to administratively close those down, or at least facilitate the closing. Otherwise, there's kind of this in perpetuity, they're out there with negative balance, continuing to have to file essentially zero reports, and that just kind of is an invitation for more campaign finance complaints and an accrual of this issue. So, but just note from the practice standards and approach, this is before the administrative courts, and the rules that govern this process are procedural rules applicable to general services cases. A copy of those rules can be obtained from the Office of the Administrative Courts. It's at 1 CCR 104-1, and by reference, they do those procedural rules do incorporate, to the extent practicable, the rules of civil procedure apply to matters before the OAC, as do the Administrative Procedures Act. So those things to be aware. If you've not done actions before the administrative courts before, I recommend strongly that you familiarize yourself with the OAC rules and the procedural issues. And it's a little bit more relaxed in terms of the standards and the approach. It's a bit more informal because you're in front of that, but it is something you need to be aware of as you're doing that. The other thing that's important for practitioners to note is you don't do filings via ISIS. The administrative courts has their own standalone filing platform. It takes a little bit of getting used to, and it's a little bit unwieldy because, quite frankly, the filing system is oriented towards workers' comp claims, and most of the cases that are before the OAC. But with a little bit of practice, you can figure out how to shoehorn in whatever filings or pleadings or entries of appearance you want to use. And that's available through the Office of Administrative Courts. Frankly, the easiest way to find it is just Googling Case Connect Office of Administrative Courts. It'll bring you to the right section where you have to kind of follow a filing wizard to kind of guide you through how you upload your filings and your pleadings and your entries of appearance and your briefs and your motions and stuff. But it is different from the perspective of most practitioners that are much more familiar with using ISIS or previously Lexis. So let's move on. Exactly. So we talked about the initial response. Initial response typically begins with a entry of appearance if you're putting in your entry of appearance on behalf of a responding party. Or if you are the responding party, or if you're the candidate responding, simply a typical approach would be a motion to vacate the hearing and set the new hearing date or hearing date for moving the case along. The other thing that does come into bear, and we're seeing more and more of this, I think earlier I didn't see very much affirmative discovery being done by respondents. Typically they bring their exhibits or they present their case at the hearing or whatnot, but we are seeing increasingly, particularly with one particular complainant, the use of administrative ALJ subpoenas to attempt to obtain additional information. And this is something that for ALJs in particular to be mindful of abusive discovery, and for attorneys as well. While we've normally seen subpoenas being administered by these private parties asking the ALJ to sign off on a subpoena, under the Administrative Procedures Act and the ALJ, or excuse me, the Office of Administrative Courts process, private attorneys can also serve subpoenas in terms of discovery just as you would in a civil claim as well, being mindful of the deadlines in terms of response. But subpoenas can be issued by the ALJ or pursuant to OAC Rule 18C, an attorney representing a party can also issue a subpoena or a subpoena ducis tecum, requiring the attendance of witness or the production of documents in connection with these campaign finance complaints. This is not something I see very often in attorneys filing subpoenas, because normally the Fed would indicate that most of it's in the public record or it's a function of a mailer that you've got, so you put a copy of that mailer in your initial complaint, and that evidence is part of that initial evidentiary record. But it is something that is possible.
Right, and what I will say that we've done with attorney-issued subpoenas, and frankly, this is one of those things that if you've practiced in mostly federal courts or state courts, when I used to do a lot of this type of work, it's in federal courts for the federal government in DC, and I moved here and first heard this, it struck fear in my heart. But the idea that your attorney-issued subpoena, because of the time frames, you issue a subpoena basically for someone to appear at your hearing as a witness, right? And so maybe you've only got 15 or 25 days or something for that. and you basically do a subpoena duces tecum for them to bring whatever document you need from them to the hearing that day. And so if you, you did not learn in law school that the first time you see a document or exhibit from a witness could be when that witness is on the stand. Like just the thought of that is somewhat frightening. But I'll give you an example of when that's the case. You talked about mailings, right? So one of the things that we didn't really get into in the earlier discussion about electioneering communications or express advocacy is there's a dollar threshold, spending threshold. So you don't have to file an electioneering communications report until you spend $1,000 making electioneering communications, which is my answer to the Facebook question, by the way. Did you spend $1,000 on Facebook or not? But put that aside. So I can get a mailer, but when I get the mailer, it doesn't tell me how much money they spent sending that mailing, for example. So one of the things that you might want as a document is if you have someone from the mail house coming in as a witness that day to say, yep, we're the people who sent this mailer, we were contracted by this committee to do this mailing, and here's the invoice for how much they paid for this mailing. And that sort of invoice document is not in the public record. That's not going to be in Tracer even if you have the mailer. Now you need to do some due diligence beforehand and maybe you've talked to them off the record, but if you need to subpoena your witnesses to show up at the hearing, sometimes that's when they're bringing documents with them to the hearing as well. So we've used it in that sense as attorney-issued subpoenas. We also have had a few cases where even in the short time frame, sometimes we can do a notice of a 30B6 type deposition for an organization to say, hey, we need to talk to who's the right representative to talk about the things that you spent and the things that we're discussing in this case. And maybe you can get a 30B6 deposition, one squeezed in before your hearing date.
Otherwise, it's you show up at the hearing and you ask the questions, you're not necessarily sure what the answers are going to be, but that's what's happening in open court and before the ALJ judge. Now, how do you respond? So you're talking about, okay, you're trying to get this information from the complainant's perspective. If you're the respondent and you think that the subpoena that you just got asked for is so overbroad, for example, this particular subpoena was received asking for financial records for third parties, for outside groups, and how do you respond? Well, CRCP Rule 45C2C allows the respondent to file written objections to the subpoenas, saying they're overly broad, they're not relevant to the claims aren't, there's no basis in the law to justify the claims to begin with, so we should put a stop to all discovery with respect to this issue because a motion to dismiss is in order before discovery happens. All these different arguments that you might lay out, how do you respond appropriately? Well, the appropriate response is under 45C2C, you need to file a written objection to the person filing the subpoena. That you are objecting to them on this basis and lay out specifically. It's overly broad. It doesn't identify whatever it is. And then typically the person would respond and say, fine, I'll narrow it to the scope. Rather than asking for the last 5 years of your bank records when I'm talking about one particular transaction, you would narrow the subpoena to the proper scope of that particular allegation or that particular mailer that you're trying to identify how much money was spent on it or whatnot. We also are starting to see, unfortunately, subpoenas of third parties, outside organizations, political consultants and vendors.